A laughing heir is a distant relative that lacks an emotional connection to a decedent but inherits some or all the estate. A testator died after the only beneficiary of his will, and his distant relatives laughed all the way to probate court in Flannery v. McNamara. William White executed a will leaving all his property on his death to his, quote, beloved wife, Katherine M. White, unquote. White's will didn't state who should inherit his estate if Katherine predeceased him. The couple didn't have any children. 20 years later, Katherine died, leaving her husband and 2 sisters, Helen Flannery and Margaret Moran. White maintained a close relationship with his in-laws and told them they'd inherit his house and its contents. White's attorney, Paul McNamara, asked to review White's will, but White refused. White told McNamara his will said that if Katherine died first, his in-laws would receive his property. White died. Because Katherine had already died, White's estate would pass to his heirs pursuant to intestacy laws. The heirs were identified using genealogical research. Flannery and Moran filed a complaint, asking the court to reform White's will and declare them the rightful beneficiaries. Reformation is an equitable remedy in which a court alters a document. McNamara, the administrator of White's estate, and the heirs were the defendants. The heirs asked the court to grant them summary judgment. The court found for the heirs, noting that the will was unambiguous and Flannery's extrinsic evidence about White's wishes wasn't admissible. The Supreme Judicial Court of Massachusetts heard the case on direct appellate review.